another entity called Keiko Specialties. It's essentially a construction business, Your Honor, underground utilities. They have been 50-50 owners for a number of years. There was a falling
As
out.
I understand it, you're just wanting them to return the documents. Is that the deal?
You got it, Your Honor. They're making some pretty extreme allegations that there's been forgeries here. They're going to do criminal referral, things of that nature. But Your Honor, here's the thing. We've got a motion to compel arbitration. There's an arbitration provision in these documents. It was initially set, that hearing was initially set for August 5th, but it's been moved to August 29th. The opposing party, Carl Coble and his attorneys, are saying that they've got a handwriting expert who's reviewed the original signatures. And we want our expert to have the same courtesy and opportunity to review the documents unfettered without somebody looking over her shoulder, just like their expert got the opportunity to do, Your Honor. We had a mediation earlier this year, I think sometime back in February with Will Pryor. During the mediation, Mr. Altick asked me to provide a copy of the originals with the stock certificates and the company agreements. And I said, sure, with no indication that they were going to withhold them and keep them and then put restraints on our ability to get them back. The bottom line here is, Your Honor, we exercised in a provision under the company agreement to oust, for lack of better words, Mr. Carl Coble from the company because of some extreme conduct and inability to get work sites done because municipalities refuse to have him on the work sites. And so there's a provision that says if he's engaged in conduct that's detrimental to the company, he could be ousted, and we exercise that option. That is being disputed, and that'll be an issue for you to determine on whether that should be determined in arbitration or not at the hearing on the motion to compel the arbitration. Bottom line is, we need those documents to rebut their expert. Our expert should have a free and unfettered opportunity to review them. If they're worried about altering of documents, then first of all, that's not going to happen. We're a reputable firm. We're reputable lawyers. We do things the right way. But heaven forbid, if something were to happen, then we'd be faced with spoliation issues. So there are remedies in case something happens. But I'm representing to you, Your Honor, the court, and to opposing counsel. We're not going to alter those documents. No way. So we just need to have them back. And that's where we're at. I can elaborate further, but the court has read the brief, is aware of the issue.
All right, let me just hear from Ms. Rittenberry.
Sure. So from our point of view, we received the books in mediation. That's correct. We retained a handwriting expert, and the handwriting expert advised us that two things. One, the signatures on the stock certificates and the various company documents were not Carl's. Two, the person who signed Tom's certificates also signed Carl's part of the certificates. So one person signed all of these altered company documents, which are conveniently allow for this ousting without consideration, without notice, without anything that, and Carl, of course, has made, found evidence of, through financial records, of embezzlement. So yeah, we're claiming forgery, and we don't want to give these documents, which are a substantial part of the evidence of our case, back to the person who we believe has already committed forgery. So we're just trying to exercise our reasonable degree of care to preserve the evidence, which is crucial to the case before us.
I mean, I think you understand his issue, which is he had the documents, he gave them to you, now you're not giving them back. I understand the concern. Well, can't you make copies of them just so you don't have to do this?
Yeah, we offered copies to him, and we also said, hey, your expert could come into the office, check them out. There's a rule that allows copies in lieu of originals, so we wanted to pass those along. They said, nope, copies won't do it. We tried to work with him on times for his expert to come in.
I guess why should your client have the originals as opposed to his client?
Another option would be to have a third party just hold on to them. We're very open to that so that, neither of us are touching them.
Yeah, I kind of thought of that myself. Is there a way to do that, Mr. Alford? Is there somebody that's trusted by both sides, or I can appoint somebody, or it's just
Yeah,
gonna
we would
cost
love
money
that.
if I do it?
Well, I guess, I mean, look, Your Honor, all those issues that opposing counsel just raised are hotly disputed. I mean,
Sure.
we could go into a litany of things that Mr. Carl Coble has done and question his competency and in his stability, but those are all disputed. I think the bottom line is from our perspective, Mr. Carl Coble has been ousted from the company. There are original share uh, stock certificates and things of that nature that banks and financial institutions sometimes need to review and make sure from a lending and banking perspective. And to have these in possession of a third party, I think is extreme and is not warranted here. I mean, yeah, there are people that we could think of. I mean, we could use our mediator, Will Pryor, to hold them, but their expert got a chance to review the documents in their expert's controlled environment using all their equipment. Our expert has got equipment. They need the originals to look at it. I'm sure the court's familiar. This isn't the first handwriting expert issue this court has come across. And so my understanding, they've got their own equipment that they need to review the original signatures and the keystrokes, the pen strokes. And I mean, look, we've got witnesses to Mr. Carl Coble being present.
Is there anything, I guess there's two ways we can handle it. The one I think that makes the most sense is giving it to a third party, and then you guys can have that. It could be Will Pryor or somebody else. I'm totally flexible on that. But the other option would be, and I just don't know the answer to this, if there's anything in the corporate documents that indicate who the custodian of record is, to go to that custodian of record. If it's not clear in the corporate documents, and there should be something, I would assume, in the business organizations code that covers who would be the custodian of the documents for the company, and then it would need to go to that custodian. I do think that having an impartial third party is probably safest for everybody.
I agree. And we're fine with Will being the holder because we trust him.
But I
mean, given the extreme circumstances, I think that it makes the most sense because we're not trying to hold them to cause delay or frustration. We're trying to preserve the evidence. We think that Tom is an embezzler and a crook.
This is so offensive because the documents are going to be in the possession of either my firm or in the possession of our handwriting expert. So I don't understand why my firm, myself, and Mr. Beck's integrity is being challenged this way with no basis for it. In 23 years of practicing, I've never even had an award of sanctions for fees against me ever. Neither has Mr. Beck. So I don't understand.
Be careful about making that representation. I better add, I don't know that, I don't remember that you have, but I've had attorneys to say that before to me, and no, I sanctioned you 7 years ago, and I don't sanction people that often, but it's not you.
I wouldn't make that representation.
So there's two options, I guess, Mr. Alford, there's three options at this point. One is you figure out who the custodian is of the records, and then it would go to that person. I'm not sure who it is. The second option would be you guys agree to a partial third party, or the third option is I'm going to let it lie and leave it with them since they have the documents currently. I think what's the safest and wisest way to do this is give it to a third party, but I don't feel like I have the ability to order that. And so that's kind of how I would approach it.
May I, I'd like to ask one follow-up for our expert. To be able to review the original, can we have an exception that the expert and only the expert have possession from a chain of custody standpoint to be able to review these documents using her specialized equipment to be able to do so without having an opposing counsel or anybody else looking over her shoulder the same way that their expert was able to review the documents?
I don't necessarily have a problem. I don't have a problem with that. I think there needs to be, what my fear is, and I don't want this to happen, is that I don't really like what Mr. Rittenberry's firm did. It's just like getting the documents from me, not giving them back. I don't like that. I don't know that I can really do anything about it, but I don't like that. I don't want this to become a game of tit for tat where you're going,
I
now
will,
I have them, you can't have them back, and then she petitions the court. I can see this going on. And so my suggestion, again, this isn't an order, is my suggestion would be, Ms. Rittenberry, that there be something in writing that indicates, okay, if we're not going to go the two routes that I've suggested, that there be something in writing saying that they return, that you agree to give it to the expert returns to return it back to you.
I would be happy to do this on the record and then follow it up with an agreed order, Your Honor, that the originals would go to our expert directly, with, to keep a chain of custody or chain of title, if you will. And then and we'll stay with her and her only. And then upon completion of her review, then I would be fine having those documents returned to Will Pryor as a neutral third party to hold until this issue is resolved.
Okay,
It's Rittenberry,
I think that's fair.
All right, so we'll do that as a Rule 11 agreement. Does that agree to, Ms. Rittenberry?
Yes.
Mr. Alfred?
Yes, thank you, Your Honor.
Get me an order that indicates that. Actually, get consent from Mr. Pryor that he'll do this. I don't want to, and if he's going to
Understood.
charge for it or how he's going to do this, subject to approval from Mr. Pryor, which I'm not going to order him to do that if he doesn't want to. But the Rule 11 would stand. So get me an order with once you get Mr. Pryor's consent, and you guys have a great rest of your day. Okay.
All right. Thank you,
Judge.
Your Honor.
Thank you, guys.
Thank you, Your Honor.
All right. Is there anyone here on the dismissal docket I haven't spoken to? I see that we have a number of the attorneys on the Jackson v. Preston Towers case. Is everyone here? It doesn't look like it.
No, Judge, we expect that Brad Lamberth will be here and also attorneys for Preston Tower.
And Mr. Collier, what are you here for? Is he on this case?
No, sir.
What are you here for, Mr. Collier?
I'm on Pimentel.
On what?
Pimentel. It's at 10 o'clock.
Let me see. Do you guys have an agreed order for the trial setting, or do you need a hearing?
I believe we do. I just got an email from opposing counsel. There was some, I think, just clerical errors on 2 of the dates. So we may need to just make sure that's the case, but I do believe so.
I don't mind getting you guys started before this case ahead of you is going to take, I imagine, some time. And so you probably want to get out of here as quickly as you can. So if you want to get him on, I can take care of that.
Okay. I don't see Ms. Adaremi on my cell phone. I'm having issues with the computer, so I can't
That's
see
okay.
who's all participating.
That person is not here. The only non-court staff people here are on the other case. It's going to take some time. So
okay, let me see if I can get her to pop on.
Mr. Collier, she's signing on right now.
Oh, excellent. Okay. Thank you.
Ms. Otterami, are you there?
Yes.
Good morning.
Good morning.
Your opposing counsel is here, and we're about to start a pretty long hearing, a potentially pretty long hearing. And so I was hoping to get you guys out of here as quickly as we could. Do you guys have an agreement as to your scheduling conference, or is there anything we need to chat about?
At this time, we are in discussion. I think we're almost to an agreement on the scheduling order.
I think if it helps, Your Honor, there's just line 4 and line 8, I think is just a clerical issue. I know you can't see it, Your Honor, but I think just the date's right. It's the year that's wrong. Ms. Adaremi, what do you think? Is that your opinion too on line 4 and line 8?
Yes,
It should be 2023.
exactly.
Yeah, so if we agree on that, Your Honor, then we can, Ms. Adaremi, can you fix those 2 dates and then send it to Judge Hoffman as a proposed order?
Absolutely.
What is the trial setting? Because we do need the trial setting today.
June 19.
Is that a Tuesday? We start trials on Tuesday.
It's a Monday.
So let's go ahead and put it as June 20th. Rhonda, we're going to go ahead and set this case for trial on June 20th. And have you agreed to a mediator?
No, but we're not opposed to a early mediation as well on this one.
What, who do you guys like using?
We typically use Martin Terry. I don't know
Who?
if Mike called someone else. Martin Terry.
I've heard good things about him. Do you want to use him, Mr. Colliers, or someone else you like?
No objection to that, Your Honor.
Okay. All right. Go ahead and put down Martin Terry as the mediator, and you guys are excused. Just get us the order as soon as possible.
All right.
Thank
Thank
you,
you.
Your Honor.
Jim.
Hello, Judge Merritt.
How are you?
Good. Let me put us into, I'm going to put us into a breakout room real quick.
Okay.
Okay, Rhonda, are you-
Yes, Judge.
so go ahead and put Judge Merritt is going to help me with the trial docket tomorrow morning, the bench trial docket. So if you could put that on our calendar.
Will do. Okay.
All right, it's everyone that needs to be here on the Jackson case here.
Yes, for Mr. Jackson.
I believe so, Your Honor.
All right, let's go on the record on DC 1913360, David Jackson versus the Preston Tower Condominium Association. Council parties, everyone here associated with that case, go ahead and make your announcement.
Nicole LaBeouf for plaintiff, David Jackson as trustee for the DRJ plan.
Your Honor, Mitchell Madden on behalf of Payne Alstron.
Jim Sauter on behalf of Preston Tower Condominiums Association.
Good morning, Judge. I'm Brad Lambert. Was the mediator.
And I have Mr. Jackson here with me.
There's a Jennifer Smiley that's here. Is she here on this case?
Yes, Jennifer Smiley, also for Payne Alstron, Christina Alstron, and Christopher Payne.
All
Your
right,
Honor, Melissa Johnson, I'm here, I'm Mitchell Madden's law partner here on behalf of Payne Alstron.
all
Your Honor,
right,
Miss Smiley is our defense counsel on the malpractice claims.
okay. Chad Smith, are you here on this case, or James Davis, or Christina Alstron?
Yes,
No,
Miss
Your Honor,
Alstron.
I'm here for the Vista Bank Vanguard substitute service hearing.
Okay.
Miss
Anyone else here on
Alstron.
this?
Miss Alstron is on this case, Judge.
Okay. I've taken a look at all this. I will say this, I'm not super pleased with how this is unfolding. So I want to start off with just dealing with this kind of an order. I don't know that I'm needing a whole lot of argument on this. First off, Mr. Lambeth, I am sorry that you're going through all this. I don't think that this was the appropriate way to handle this, and that you being attacked for doing your job the way you did really was unnecessary. And I apologize if you went through any type of stress as related to how this was handled. And so, you know, I don't need to hear anything from you. Everything that you've done was, as far as I can tell, was appropriate, and you need to, you don't need to worry about this court being concerned about your activities in any way. So you're welcome to stay on if you want to, but I don't see any need to have you stay on.
Okay. Well, with that, Judge, thank you very much. I do appreciate the opportunity to work with these folks, and I think it's close, but hopefully they'll be able to get it resolved. And thank you for your time, and I'll go ahead and sign off.
All right. Thank you so much, Mr. Lambert, and you have a great rest of your day.
Thank you, sir.
Okay, second issue here is the settlement agreement. The settlement agreement is discoverable, and so it needs to be turned over. I'm not sure why it's been withheld as long as it has been, but it needs to be turned over. So, Ms. LaBeouf, you need to get that over to Mr. Madden within the next 7 days. And then the final issue is, should we substitute a mediator? Do you still, he's made it sound like this case was almost settled. Is it almost settled or not?
Judge, Mr. Jackson is at $500,000, and depending on which transcript you read or which pleading, Payne Allstrom is somewhere between 120 and 380. So we're pretty far apart. There has not been discovery. It's a brand new case between us. I thought we could do it with Mr. Lamberth because he'd spent days literally both before, during, and after talking to everybody. But now at this point, I don't believe it's ripe. I believe we need to get the depositions of Payne and Allstrom and probably a few other people so that we can actually have a chance of getting it settled.
All right, I'm going to go ahead and order it to mediation now. I don't think that at this point it would be fair to Mr. Lamberth to order it to go to him, given the history. And so King Pfeiffer is who's recommended by Mr. Madden. He's an excellent mediator. He's actually who I was thinking of when I heard it, when I was kind of reading through this, like, King would be a great former colleague of mine. I think he's a great mediator from what I've heard from all sources. But if you don't want to use him, we can use somebody else. But you're going to mediation. So who do you want to go to mediation with?
Yeah, I'm glad that you asked. We would be interested in Bob Genevine or Jim Jordan.
Those are both fine with me. Both excellent mediators, Mr. Madden.
Judge Genevine would not be appropriate for this case. Judge, excellent mediator. I would use him in a heartbeat. I've never used Judge Pfeiffer, but it was recommended from somebody that I would trust and rely upon. I don't know. I've never mediated with him. My clients have never mediated with him. So that's why, unless Mr.
What
Knopf
about
has
Jim
some
Jordan?
Judge Jordan is fine as well. I haven't talked with my clients about it. And Judge, in my COVID fog, the last time I agreed too early to Mr. Lamberth, I apologize to you. Okay. It's my fault. It's my fault. I said, okay. I didn't know the full background. It's my fault. But I'd like to figure out if Jim Jordan, is there anybody other than Jim Jordan that I can go back to my clients with today and get an agreement?
You're cutting out.
Is there anyone other than Judge Jordan? Because I'd like to just check with my clients now before I pop off.
Ms. LaBelle, why don't you give a third name that you can agree to? Who's that?
Well, I will, but now I have to go back and confer with folks. We like Judge Kaplan, but I think he's probably a little pricey. So
Judge Kaplan's excellent, and this is a complicated case. You want somebody who, one thought I had was you might want to have somebody who understands contingency fee contracts, because that's really kind of, is this a contingency fee? Is it not a contingency fee? How that all plays out. I don't know. One of my thoughts was having either a judge or having a former judge or having somebody who's maybe a former plaintiff's attorney who really understands how contingency fees work and all that kind of stuff. But I just can't, there's not a whole lot of former plaintiff's attorneys that are down doing, mediations. But somebody who kind of understands those issues, because I think that's, or medical malpractice or legal malpractice cases. Does Randy Johnston ever mediate? Does anyone know?
I'm not aware of him doing it. We wouldn't be opposed to Mr. Toby, but I don't know if he does either.
Yeah, either of them would be good. Somebody who has a real understanding of kind of, this is all at this point a fight over attorney's fees. Let me text Mr. Toby and see if he ever mediates. I don't know if he does. Actually, I'm going to call him just so this is totally up so that you guys will. He might have a suggestion on who's good at attorney's fees issues.
Well, it's definitely a malpractice case, Judge, but if you'll ask him about both.
Hi, Judge.
Hello, Mr. Toby. I'm in the middle of a hearing right now and wanted to chat with you real quick. There's a number of people on Zoom. They should be able to hear you.
Okay.
We have a case right now that your name has come up as a possible mediator for it, but you may not do that and you might be able to refer us. But it's essentially a case where plaintiff's firm was fired. The firm was fired, and that former plaintiff's attorney was fired, and then was arguably on a contingency fee, although it's not the clearest contingency fee. And then the underlying case settled without satisfying that lien, alleged lien. And then now the defendants have counterclaimed for malpractice. Plaintiffs are suing for their fees. And so I want to get somebody who can mediate this, who has a pretty good understanding of all of the kind of attorney's fees, legal malpractice issues, contingency fees. And so I thought of either you or Randy, but if there's somebody else you think would be good, or if you guys would be willing to do it, I think this is right up your alley.
We have mediated a handful of cases like this. We don't consider ourselves, a Chris Nolland or a Ken Rubenstein or one of those guys, but we certainly have mediated these types of disputes and would be happy to do it, assuming we don't have any issues with any of the parties. I can't imagine what that would be in the mediation context, but.
Well, just let's make sure you don't have, I doubt you do, but let's get all so the underlying firm is Payne Alstron. They were the original plaintiff's firm that's claiming a lien. Do you have any business relationship to them?
What's her first name? Payne?
Chris Payne and Alstron.
Christina Alstron.
Do you have a business relationship with them?
No.
Okay. And then their attorney now is Mitch Madden.
Okay.
I don't know if you have a business relationship with him. And then the defense attorney is Nicole, or not, the new plaintiff's attorney is Nicole LaBeouf. And the defense attorney for the other side is James Souter. And I'm sure I'm missing somebody. Anybody else? Jenny Smiley and James Davis, I think, are also involved in the case. Am I missing anybody? All right. You've never represented any of these folks?
No, we don't.
Okay.
I don't believe there would be any issues there.
How do y'all feel about, would you rather do it, or do you think Randy would rather do it?
I don't think Randy would care. So I'm happy to do it.
Okay. Any opposition to Mr. Toby?
No, Judge, we approve.
Mr. Madden?
Judge, subject to our defense counsel, Ms. Smiley, my clients approve.
Ms. Smiley? You're muted. I can't hear you.
Oh, we approve. I approve.
Okay. Everyone's approved you. This case is it's convoluted, and it's one of the more unusual contingency fee contracts I've ever seen. But you'll get it's some really interesting attorney's fees issues, and what is the lien, and who's responsible for it. And then there's legal malpractice issues, so that it's going to be complicated. They've already, you guys have not mediated, the underlying case was mediated, but this issue has not been mediated yet, right?
This issue has been mediated and continued.
In the underlying case, it was when you mediated, it wasn't independently mediated.
No.
Okay. So, Mr. Toby, could you fit them in the next 30 days, do you think, or do you need 60?
I could do it in 30 days.
Does that work for everyone else?
Judge, we believe very strongly we need at least 60. There's got to be some discovery.
Mr. Madden?
Judge, I can work it in.
30 or
30
60?
days. 30 days is fine if the court.
I'll do the Solomon approach. You have 45 days. So Miss Pinson, go ahead and put down Robert Toby. You should be able to find him. Robert Toby is the mediator, and it'll be mediated within 45 days. So go ahead and set out a new mediation order on this. Mr. Toby, thank you for your service to the court. Hopefully this won't be too painful. And I instruct the parties that I don't want to have happen what happened in the last one. Mr. Toby, just because you don't like this case, or this case doesn't settle, doesn't mean you need, the last case, there was some issues where they tried to, anyway, you can read the underlying file. The cause number on this is what again, DC? What's the cause?
1913360.
DC 1913360.
Thank you very much, Your Honor, and I look forward to trying to get this done for you.
Good luck. Thank you, Mr. Toby.
Thank you, Judge. Appreciate it.
Okay. Bye-bye.
All right, we have a couple housekeeping matters I need while
Sure.
we're on a record. We still have some orders that we've submitted and resubmitted that we'd ask the court to sign.
Which orders?
It was in the underlying case. There's the declaratory judgment, the order granting the motion to strike plaintiff's 7th amended petition. That was submitted May 10, 2022. The first one submitted December 22, 2021. And the order denying plaintiff's motion for continuance, which was submitted on May 10 of 2022. And then we've
Okay,
been,
whoa. Let's go through those one at a time. So I can look them up.
first was the declaratory judgment.
All right, so when is the first one?
It was submitted on December 22nd, 2021, but it's been resubmitted since.
Do you see the order here? There's been a million things filed in this case.
I think yeah, I can't
Is
even
this
tell.
one here, proposed order?
That looks right, Judge.
Rhonda, do you see that?
Yes.
All right, yeah, I do think I granted this. I'm a little unclear. Why do we need to sign these? Because this part of the case is settled, right? Why are we doing this?
Judge, we're just making sure that we have a clear record as to what happened in the underlying case.
I mean, are you trying to get out of the settlement, or Mr. Souter, how do you feel about this?
No, we're not trying to get out of the settlement, Judge.
Your Honor, we're not trying to get out of settlement either.
I'm just wondering, are you concerned about me signing these orders at this point?
I don't think so, Your Honor. They're rather old orders, or they've been around for a while, but I don't think I have a problem.
All right, Rhonda, go ahead and print this order out. Did you see when it was?
Yes, December 22nd.
Go ahead and print that
Yeah,
order out, and I'll go ahead and put it on my stack, and I'll go ahead and sign it, and then put on the top that this case, please sign order per hearing. All right, what's the next one?
The second one was the order granting the motion to strike plaintiff's 7th amended petition. It was submitted on May 10th, 2022.
May 10th, okay. Okay, wait a minute, May. Do you see the order anywhere?
I think we're down a little bit more, Judge, I believe. No, probably here.
10th, is that it? Granting, what is it? What was it you said again?
Probably granting.
Let's see. Granting, order granting defendant's motion to strike plaintiff's 7th amendment petition. Is that what it is?
Yes, which
Mr. Souter, do you have any opposition to me signing
No.
this?
Not at all, Your Honor.
Ron, did you see that one?
Judge, Mitchell Madden, I need to look at this order. I'm sure that since this case was consolidated and we now have moved forward with these claims, that you have in effect allowed my clients repleading regarding claims against the association.
I can't hear you, Mr. Madden.
I believe that you've allowed our claims to go forward against the association that would have been subject to the 7th motion. I think that your subsequent ruling at a subsequent hearing made that clear, but I'd like to look at it and I'd like to follow up with you.
Judge, this only had to do with plaintiff's attempt to amend his petition to add claims. And you did grant it.
That's correct, Your Honor. It did not address, I did not address Payne Austrin's interpleader in any way.
Yeah, intervener.
Intervener.
Right.
And then we have order denying plaintiff's motion for continuance. Is this the other one?
Correct.
On May 16th, no, I don't know about that one. That was probably signed.
Okay. What's the other one? This was on May 9th, 2022.
Yeah, I don't know about that one. But then on May 16th, we had one that was I'm sorry.
I don't see any
No,
order.
you're right. You're exactly right. I just switched over to the transcripts we're waiting on. I'm sorry. That was May 10. Yes, denying plaintiff's motion for continuance. You were exactly right.
All right, do you see that? Where is it now?
Sorry.
There's just so many things filed here. Right here. So this one too, Rhonda, the order, proposed order .9 on May 10th of 2022. Go ahead and print that one out for my stack as well. Was there another one, Ms. LaBeouf?
No, Judge, we just have 3 transcripts we've been waiting on for about 6 weeks now.
Tony, what's the status on those?
I'm just like everybody else. I'm just so backlogged. I'm working on it. It's being worked on. I haven't had a chance to get it approved, but I have like 3 trials on appeal this week that I got to get those out first, but I'm trying. Hopefully it'll be ready, sometime this week.
Thank you, Miss Tony. All right. That's all we got, Judge, for housekeeping.
Anything else, guys?
For my judge.
All right, you guys just get me an order on all this, Mr. Madden, and we will, especially on the order compelling the production of the settlement agreement, that needs to be, make sure the order says at the beginning that this was heard on August 1st, 2022. Email it to Rhonda. You might want to call her too, because she's kind of busy, and then e-file it as well.
I will do so now, Judge.
All right, thank you. And make sure you share it with Ms. LaBeouf.
We do have an unusual circumstance in that there's 2 sets of lawyers. I don't know how unusual it is, but representing Payne Allstrom. I assume that the insurance counsel is also ordered to be at mediation.
Everybody's ordered to be at mediation, Ms. Smiley.
Okay, understood.
Okay. Yeah, and everybody on both sides, including Mr. Souter, everybody has to be there. Okay. Does that make
Understood, Your
Mr.
Honor.
Souter? Is that good?
Yes, Your Honor. I understand.
Good luck, guys.
Thank you, Your Honor.
Thank you. All right, next one is Vista Bank versus Bright Vanguard LLC. Anyone here in that case?
Chad Smith, Your Honor, on behalf of Vista Bank.
Anyone here for the defendant? All right, let's go ahead and proceed.
Your Honor, we're here today on 2 different motions for substitute service. When Vista Bank originally filed this case, there were 3 different addresses in Texas listed for the defendants. The constable was able to confirm one of those as the address for Nibeth Davis. But by the time the court signed the order for substitute service allowing posting at that residence in March, the constable went back out and was informed that the house had been sold and Miss Davis had moved to California.
Okay.
So I filed 2 separate motions for substitute service, one in April and one in June.
Okay.
We want to either be able to serve her through the Texas Secretary of State, since we believe she's now a resident of the state of California, or alternatively serve her by publication if the court doesn't believe we have enough information to show a good address in California. Or Vista Bank's willing to do both, Your Honor, to get this case moving forward.
Is there a way to do this via social media?
I don't have her email address, Your Honor. I can do some searching and see if I can find one.
Who is it you're trying to serve? Nabeth Davis?
Yes, Your Honor.
I mean, have you tried to find her on Facebook, LinkedIn, Instagram, anything like
I have,
that?
Your Honor, but I don't know if the person I'm finding is actually her.
Yeah.
I've never met these people. I don't know anything about them.
So do you see, let me share screen this, because this is why this is kind of an issue. So this is what you guys submitted here. Is this from the process server, or what is this exactly?
That is from the constable when she went out there to post on the door.
Okay. Thanks. First CAD house was in both defendants' names, but was deeded over to her. It was 2021. Okay.
Your Honor, I've run a background check and all the background check information that I have goes back to the 3 addresses we had in Texas.
Okay.
There was an address that they had provided on a financial statement that was submitted to Vista Bank. And
let me just tell you how I kind of do this. So if you have something from a governmental entity that shows that she owns a piece of property or owns a residence, I'll usually allow you to serve at that place. If you have, I'd rather do that than publication. And so, or if you have, she owns a vehicle and can be served at that particular location where the vehicle's registered, I'd rather do that than serve it be publication.
Your Honor, all the addresses I've been able to locate go back to 3 addresses in the original petition.
Okay.
Now, the address on the substitute service we filed in June, we had an affidavit of Blair Mercer that talks about the personal financial statement that they had provided in June of 2021, listed an address of 1191 North Bundy Drive, Los Angeles, California. And so that was the address we were going to use if we served through the Texas Secretary of State to have them forward to that address.
Okay. Just, yeah, give me an order on that, and if that's the case, I'll go ahead and sign it.
Okay, through the Secretary of State, or do you want us to publish it as well, Your Honor?
I don't need you to I mean, publication is nothing. So posting, if you have an address to post it, that's fine, but I don't want to publish it. I don't think there's any need to.
Okay, I will make sure and get that order uploaded, Your Honor.
And then make sure that you indicate at the beginning that this was heard on August 1st, 2022. You email it to Rhonda and e-file it as well.
Yes, Your Honor.
Thank you. You have a great rest of your day.
All right, thank you, Your Honor.
Thank you. All right, our next case is Pinky Properties versus Tarrant Roofing. Are both sides here? It's probably a little early for that. Are both sides here for that?
Counsel for defendant Tarrant Roofing is here, Your Honor.
Okay, but it's not time yet, so how long do you anticipate this here? It's just a motion for leave, right?
Yes, Your Honor.
It should be pretty quick.
That would be my expectation.
Let me see. Mr. Tufnell, are you here for the Pinky Properties case? Oh, he went away. Mr. Tufnell, are you here for the Pinky Properties case?
Yes, Your Honor, I am. I'm so sorry for that.
That's okay. Happens all the time. Are y'all here on the motion for leave?
Yes, Your Honor.
Tony, you ready? Let's go on the record on DC 205783 Pinky Properties LP versus Tarrant Roofing. Council, make your appearances.
Jeremy Tufnell on behalf of plaintiff Pinky Properties LP.
Karen Denny on behalf of defendant Tarrant Roofing.
All right, let's go ahead and proceed.
Thank you, Your Honor. May it please the court, I'll just remind Your Honor of this. This dispute deals with a commercial property located in Dallas County. And it is our allegation that based on Tarrant Roofing's failure to properly clear drainage on a commercial property roof, some water infiltration occurred that was later found and required the entire property itself to be demolished. Now, for this specific hearing, Your Honor, I think a timeline is extremely helpful. While this case was set for trial on January 18th, 2022, we filed our first supplemental response to request for disclosures on September 10th, 2021. And that listed several non-retained testifying witnesses, as well as one retained testifying witness to opine as to the reasonable and necessary attorney's fees. The other non-retained testifying witnesses were designated to opine as to their reports and assessments made on the property prior to this litigation. Now, on November 29th, this court granted Tarrant Roofing's motion to strike these experts because they were designated after the scheduling order allowed at the time, or that was in effect at the time, but allowed these witnesses to remain as rebuttal experts. Now, after this court denied Tarrant Roofing's no evidence motion for summary judgment in early January of this year, the trial setting of January 18th was continued to June 21st. Now, I think importantly, after this court granted Tarrant Roofing's motion to strike, and after this court continued the case from January to June, Pinky Properties did not request leave to designate experts. Now, the week, continuing on the timeline, Your Honor, the week before depositions were supposed to be taking place between the corporate reps of Tarrant Roofing and Pinky Properties, Tarrant Roofing canceled these depositions on the basis that they had retained new counsel. And in March of this year, Tarrant Roofing filed their unopposed motion to substitute counsel. And then in May of this year, Your Honor, we continued this trial from June 21st to November 29th. And that is the current trial setting on this case. Now, this court signed the new scheduling order on May 27th of this year. And then on June 7th, we filed for leave to designate the experts that we had previously designated in our response to requests for disclosures. Now, the Texas Rules of Civil Procedure are very clear that absent good cause, we do have the burden of showing that there is no unfair surprise or unfair prejudice. And Your Honor, we believe that the facts of this case simply do not warrant unfair surprise or unfair prejudice. Because first of all, we are not asking this court for leave to get any new experts, get any new opinions. These experts have been known since September 10th and earlier on as the reports were produced during discovery. Furthermore, Your Honor, there is absolutely no unfair prejudice as giving the time until trial is set in this manner. Defendants would be able to designate rebuttal experts if necessary before 60 days before the end of discovery, as per 195.2, Your Honor, the Texas Rules of Civil Procedure. So based off on those arguments, Your Honor, we believe that there is no unfair surprise, and we believe that there is no unfair prejudice to allow us leave to designate these experts at this time, or these witnesses at this time.
Ms. Denny?
Your Honor, this case was filed by the plaintiff in April of 2020. There was an agreed scheduling order entered in May of 2021 that specified the deadline for the plaintiff to designate experts of June 11, 2021. There were no experts designated whatsoever by plaintiff at that time or before that time. Via a supplemental disclosure response in September of 2021, plaintiff attempted to designate experts at that time. Tarrant Roofing in October of 2021 filed a motion to strike and exclude experts. There was a hearing held on that in November of 2021. And the parties then filed a proposed order on motion to strike based on rulings that you had indicated during that November 2021 hearing, indicated that Mr., and I may mess up his last name, and I apologize for that. At least he's not here to hear me butcher it. Mr. Bogdanowicz. Is that close, Mr. Tufnell?
Throw a V instead of a W, but it's Eastern European, so I think we're fine.
Bogdanowicz. Okay. Striking Mr. Bogdanowicz as a testifying expert and restricting the other 4 individuals who were late designated from being able to offer any affirmative expert testimony whatsoever. They could only testify via rebuttal. The court then entered that order that the parties had filed as a agreed to as form order. The court entered that order in April.
How close were we to the trial setting at that point?
I'm sorry.
When, Your Honor?
When I made that order?
You orally stated the order in November of 2021 when there was a January trial setting.
Okay, so it's pretty imminent. All right.
And then the parties filed the order, which you then signed in April of this year. We then entered an agreed scheduling order amongst the parties on May 27th, 2022. Prior to that agreed scheduling order being entered, plaintiff's counsel and myself discussed any sort of new expert designation deadline and did not come to agreement on that. So the order that was presented to the court just had time for us to do fact discovery and provided for a new trial date in November. So now June 7, 2022, more than a year, well, almost exactly more than a year, 4 days shy from the deadline to designate experts, they're now asking to designate experts. Obviously, under Rule 193.6B, plaintiff bears the burden of showing good cause for failure to meet the deadline, which they haven't argued good cause at all, or the lack of unfair surprise or unfair prejudice. That is what they are arguing, but they have not met their burden. At this point, they claim that there have been reports provided. We indicated in our response they've identified no reports. In their reply, they still identified no reports, other than the home report that they have attached to their motion. I don't know what they're talking about as far as reports of the other 4 individuals, as those reports have not been provided. We have a November trial setting. The home report itself, it doesn't even identify or indicate that Tarrant Roofing actually caused any mold of any sort. If they're now going to start asserting that Tarrant County caused the mold that was discovered after the fire at the commercial property, many, many months after the roofing work was completed, that obviously is something that we would need to deal with, and it would cause unfair harm, unfair prejudice, unfair surprise, as we are only months away from our trial setting. and have been preparing for trial based on the understanding that there would be no affirmative experts whatsoever based on the order that the court entered. And also based on the fact we would also suffer unfair prejudice and harm based on the fact that Tarrant Roofing has already expended time and effort, as has this court, dealing with this issue. We had a hearing on it. These experts have already been struck, and we have been preparing for trial based on the understanding there will be no expert witnesses of the plaintiff whatsoever in this lawsuit. I think you're on mute, Your Honor.
What is your good cause argument here?
Your Honor, we haven't argued a good cause argument in this case. We believe that, simply as it is, we missed the deadline, and we're not going to present this court with, half arguments. We are relying purely on the fact that there is no unfair surprise or unfair prejudice in this instance. And this isn't a situation, Your Honor, in which, immediately after the first continuance from January to June with Tarrant Roofing's previous counsel, we didn't move to leave, or we didn't ask for leave from this court to designate. It was only after, it was only after Tarrant Roofing canceled our depositions the week before the depositions were supposed to be happened, obtained new counsel that required this case to be continued all the way to November 29th of this year, giving ample time ample time for Tarrant Roofing to investigate.
What are the experts exactly that you want to designate? They're the Mr. Bogdanovich,
Mr. Holm, who made the mold inspection report. Excuse me 1 second, Your Honor.
So I'm going to allow Mr. Bogdanovich. I'm going to grant leave at this point. I think there's plenty of time to do discovery on attorney's fees. So has there been mold discovery back and forth on this? Do they have a mold expert? What's the status on all that?
Our mold expert at this time, Your Honor, would be Mr. Holm, and this was
do they have a mold expert? Or
no, Your Honor, they do not. I do not believe so. Karen, I don't want to speak on your behalf.
I think that kind of reframes it, so I'm not going to allow the mold expert. What are the other ones?
They are Derek Greer, which is a forensics engineering expert, Your Honor, that I believe it was in our discovery. He was an engineer that provided an assessment on the building itself, Your Honor, and our decisions to demolish instead of rehabilitate that building, the commercial building, Your Honor.
So has there been discovery on that issue from the other side?
No, Your Honor. There hasn't been if this is the line of question, there hasn't been any sort of discovery on any of the other experts listed, Your Honor.
Do they have experts themselves on these issues?
On these issues, Your Honor, I do not believe so. Ms. Denny, you can correct me if I'm wrong.
We have designated some experts, yes, as far as, since we don't really know, so we have no reports. So I don't really know what any.
Mr. Tufnell, you said you had given reports on these.
They were part of our discovery, just initial findings regarding investigations into the property. They were not
reports or just designations.
The designations, Your Honor, was just designations. No
reports.
No, Your Honor, as they were just non-retained experts.
Non-retained experts. Okay. All right. So it's a little difficult to kind of figure this out. So what I'm trying to get at is if they've already designated experts to deal with these issues, then you can designate experts. If they haven't designated experts other than Mr. Bogdanovich, I'm inclined not to allow it. So that's kind of where I'm drawing the line, but it doesn't sound like yours exactly certain, or I'm not trying to fuss with anybody. What's the situation for each of these four experts?
I think that's a fair assessment at this time. I don't want to speak for Ms. Denny. I'm curious if giving your verbal assessment at this time, if we couldn't work out a form order, or
well, why don't you do this? Why don't you two talk about it a little more carefully at the discovery? If you guys can agree to a form order, then submit it. If not, then why don't you come back at 1:30 and we can chat a little bit more about this and try to work out the exact parameters. Does that make sense?
I admit, Your Honor, I'm confused on what we're doing here. So we don't know what these experts, they've designated, given next to no information about what these.
So let me just give you an example. I used to do a lot of personal injury litigation. So what I'm trying to get at is, let's say that you designated a biomechanical expert in a personal injury case, then I would allow him to designate a biomechanical expert if you already have an expert designated. So I'm trying to figure out what experts you have designated, because that to me will indicate whether or not you have, did you really anticipate this or not? And then if you don't have an expert designated in that area, then I would be inclined not to allow him to have an expert, because then it would reopen things for you. But if you already have an expert, him having a counter expert, I think is fair and would show that you don't have unfair surprise.
Our issue, Your Honor, is I don't have a clue what any of the people that he has designated are planning to say. So I don't know. We have designated some people, but I don't know if what they would say or the areas that we've even designated them on matches up at all, because we did our designations before he did his designations. So I have no clue if they're responsive or even the same areas, because we don't know what any of his people would say.
That's why I think you should talk about it and kind of figure it out. I mean, I'm trying to be as clear as possible without knowing what your designations are and his designations are. But like, if you had an economist, he could have an economist. If you had a biomechanical expert, he could have a biomechanical expert. Does that make sense?
I don't know if we can figure that out before 1:30 as part of the problem, because I have no clue what his are, and I would probably have to call our people that we've designated to see if they can even talk about the things that he is saying that his people would talk about now. And one thing I did want to bring up, which is slightly different here, is this continuance was actually suggested by plaintiff's counsel, not me, as far as getting the new trial date. And I actually have an email I can show, and it appears at this point that the continuance of the trial date from June until the fall was to try to get experts. So, but in any event, the substitution of counsel did not result in this continuance. It was suggested by plaintiff's counsel.
Okay. Well, why don't you, I appreciate you telling me that. Why don't you guys talk about it? If you guys can reach an agreement, great. If you can't, then let's reconvene at 1:30. Does that work okay?
Yes, Your Honor.
All right. Thank you, guys. You have a great rest of your day, or I guess I'll see you at 1:30. If you do reach an agreement on this, please submit the order to Rhonda. And so we'll take you off the docket. Rhonda, go ahead and reset this to 1:30 today. Thank you, guys.